Hi, my name is Amanda Rocha. I'm an estate planning and probate attorney in California, and today I want to talk to you about what to do with your cars. Should they go in your trust? Should they not? And if you don't have a trust, what do you do about them? Before I get into that, I want to give you my contact information. Feel free to contact me about this or any other estate planning or probate matter. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me and follow me on social media at Amanda Rocha Law. The reason I'm getting into this today is because it seems to be a topic that comes up over and over. And not only do I discuss this with my clients, but also I see a lot of other attorneys discussing amongst themselves, what do we do about this client's vehicles or this fleet of vehicles that a client has? How do we ensure that they avoid probate, and should it be in the trust? So, without further ado, here are my thoughts on the matter. In general, most people do not have vehicles of such a high value that they're going to trigger probate on their own. Right now in California in 2021, the threshold to trigger probate is owning $166,250 worth of property. That is all property. So all of your personal belongings, your vehicles, your bank accounts, the value of your home, all of that adds up together to determine whether or not your assets and your estate are going to trigger that probate need. If you have a trust, the trust will, anything held in trust, like if you have your house titled in a trust, that's not going to count toward your probate total. So even if we do a trust for someone, we don't necessarily and usually add their personal vehicles to it for a couple of reasons. The first reason is that most people's vehicles do not add up to that high value. And if everything else in their estate is taken care of and will be avoiding probate, then having a $50,000 truck or having a car and a truck worth $75,000 or even $100,000 isn't going to push you over the edge if everything else has been taken care of. Another reason is that you change vehicles pretty often throughout life. Sometimes people do it very often. Sometimes you have a car for 15, 20 years. So it's adding an existing vehicle to your trust is an extra step that you don't necessarily need to take. If you are going to purchase a new vehicle and anticipate having it for a while, you can by all means add that into the title of your trust and not worry about it. There are other things you can do to avoid probate without adding your vehicles to your trust. One is if you have a joint owner of a vehicle, if you pass away, that other joint owner will be able to take ownership and probate will not be triggered because it's a jointly owned item. This doesn't work for every item, especially real estate. So definitely only apply this to vehicles as I'm talking in this vehicle or in this video and podcast. Another thing you can do is the DMV allows you to name a person, such as a beneficiary, as a payable on death or transfer on death, I think is what the DMV calls it, transfer on death. So on the pink slip of your vehicle, there's instructions on the DMV website, or you can contact me and I can help you figure out how to do this for yourself. And this will work for anything titled with the DMV. So it could also be a boat, an RV, even motorcycles, some mobile homes, depending on how they are owned. If they have to be registered with the DMV, then this will work for them. But if they have to be registered with the Department of Housing, that's a different story. Anyway, there's a way that you can name a beneficiary on your title so that even though they don't have joint ownership currently with you, when you pass away, they will inherit it without it having to go through probate. Reasons that you might want to put vehicles or other kinds of recreational vehicles on your trust would be if they are super high value. If you have a boat worth $200,000, that alone triggers probate. If you don't want to go through the process of doing the DMV paperwork, you can always change title, especially if you don't think you're going to sell it. Now, if you have collectible vehicles, that's a little bit of a different story. It depends on if you're going to be registering them and how you're registering them with the DMV. It's best to put classic vehicles or collector's items or things that you know you want to pass on, put them in your trust. You do it once and you don't have to worry about it again as long as your trust is still active. So to sum it up, pretty much most everybody doesn't need to worry about putting their vehicles into their trust unless they have many of them that add up to more than $166,000 or would add up with other items to that amount, or unless they are high value, or if you have collectors items, classic vehicles, that kind of thing. Again, there are other ways to avoid probate on this, such as having a joint owner or naming a person to be a beneficiary, so to speak, through the DMV. If you have questions about this, please feel free to contact me. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me on social media and send me a message that way. I'm at Amanda Rocha Law. Thank you.